Well, today, a little Christmas present for the people of Canada. Hundreds and hundreds of years of law and precedent and civility were thrown out of the window by a third-rate Supreme Court that said it's okay for people who are pretending to be Muslims to cover their faces completely at a trial. This is based on a terrible incident that men charged with rape and a Muslim woman who wants to be completely covered with a niqab during the trial. For centuries now, the accused has the right to see the person who is accusing them. With protection, of course. It's not that they can run at them and grab them, but you can see the face of the person accusing you. Legally, it's extremely important. Morally, it's very significant too. We know, we've established this, that the full covering is not part of Islam. I began going to the Islamic world, the Middle East in particular, back in the late 1970s. You did not see Muslim women with covering. South Asia, Pakistan, parts of India, you did not see Muslim women with any covering. It's not Islamic, it's Saudi Arabian. It's the influence of Saudi money and extremism. It's cultural, but because of the influence of the Saudis, it is now very common, and the Supreme Court in Canada has said it's fine for this to influence, to drown our courts of law and justice. Brian Lilley joins us from Ottawa. Brian, I am a bit surprised by the decision, and I'm incredibly disappointed.
I'm not sure that I'm surprised by the decision. It's a bit of a strange one. 7 justices heard the case and ruled on it. The 4 on the majority tried to find the wisdom of Solomon, to use a religious term, as we discussed this. I'm not sure they succeeded. So 4 of them said the niqab if necessary, but not necessarily the niqab. 2 of them said we should not allow the niqab in the courtroom at all. And then one, Justice Abella, no surprise, says, well, there's no way that we should be telling women that they should ever be forced to take it off. So the majority carries the day, and those are the 4 justices led by Chief Justice Beverly McLaughlin, who said it depends on the strength of the religious belief and on what kind of case is being heard. I don't think that in the case that originated this, in the case of rape, that this woman will be allowed to testify and accuse someone of a very serious crime of rape without showing her face.
No, in this case, she will have to remove it in this case, apparently. Can I just ask you about Abella? Because I remember years ago at a party, before she was on the Supreme Court, seeing this woman who, if you've met her, is not very impressive. I mean, there are people who I disagree with fundamentally on issues of law who are very impressive jurists. They really know their stuff. She's not very impressive. She's very political. She was lobbying the position at this party. You could see her talking to people, sucking up, frankly, to the right people. She's come out with this ruling, which I don't think is even legally based. It's merely her whim, her fashion. How could she say such a thing? And how is it we have to take her seriously?
Well, I mean, you flip to the back of the ruling where her writings are, and it's all about, it's sociology. It's in the realm of Claire Huret-Dubé, the woman that used to be on the Supreme Court, that started saying, forget about law, forget about precedent, forget about what is written down, what Parliament wanted, what previous judges have said. Let's look at the sociology of this. And let's be sociologists and not judges. This is a strain of judicial activism, you might say. Mm-hmm. Now, in terms of the ruling that carries today, because Abella is pretty much irrelevant on this, because she is alone in the wilderness. All the other judges say, at least in some cases, the niqab has to be taken off. So the majority have said, if it's a serious offense, and I think that rape, murder, so on, these would all be serious offenses, then the judge has to find the right balance. And I think in the more serious cases, the court ruling says, err on the side of a right to a fair trial, which means being able to see your accuser. My feeling is that they were trying to say in less serious instances, let's say you're arguing over a property line, that maybe you don't need to see the person's face. But here's my worry, Michael, is where does this lead to, and what will lower courts stretch it out to mean in the future?
Of course. This is merely the first part of a campaign that within radical Islam can take hundreds of years if necessary. This is based on the charter idea of freedom of religion. But you know it's hypocrisy, because whenever Christians come forward and ask for their religion to be taken into account, well, invariably they're told, no, you've lost. You've lost again and again and again. A woman comes forward here, and we've established, even within Orthodox Islam, it is not a requirement to have the full covering, and yet she's achieved a partial victory. It's not about religion, it's about fashion.
And you know, you and I are big backers of freedom of religion,
Sure.
but both of us would say when it comes down to the right to a fair trial, you could be sending somebody away to jail for a long time. The right to a fair trial needs to take precedent, because otherwise you are sending people to prison unfairly. But let me just go to another point you mentioned, that this is fashion. It wasn't that long ago that the Supreme Court was throwing out an educational case where parents came forward and said, what is being taught in the schools goes against our religion. We want to be able to remove our children from the classroom, and the state won't let us. This was in Quebec.
Yeah.
The court said, no, this isn't an infringement of your religion.
Exactly.
So this same court that says you can wear a niqab while accusing someone of a crime and testifying in court says that you cannot remove your own child from a provincially run school when they are teaching things that go against your belief system.
Yes.
This is the state of the modern judiciary, and I think calling it a third-rate Supreme Court might be a bit generous, Michael.
Thank you for saying that. And one last thing. In Islam, wherever Sharia and Islamic law and the Hadith are taken very seriously in jurisprudence, a woman has about a third of the influence of a man in any trial. So think of the context here. A system that says a woman's testimony, a woman's worth is far less than that of a man in a court is the same system that the Supreme Court of this country has now listened to and concluded that a woman should be allowed to cover herself completely. This is such bad law and such bad intellectual reasoning. I hope we haven't heard the last of it. Brian, as ever, a pleasure. Thank you so much.
Thank you, sir.